Synchrony Bank versus Barbara Shop, SCHAAP. It's your motion for summary disposition this morning, Mr. Canine. Why don't you state what your position is, and we'll go from there. Noting for the record that Ms. Shop has not appeared. Nobody from her representation has contacted the court. Go ahead.
Your Honor, I would say I noticed that the notice to appear indicates that today is a motion for summary disposition. I did not file a motion for summary disposition. And at the last hearing, the magistrate said he was going to set it for pretrial or final pretrial.
So that's all it was? I've got it down for a motion for summary disposition, and that could be an error on our part. I don't know. It's
That's
not
what-
her motion.
And I know that I haven't filed one since the last hearing.
She claims that this is anybody else on the Zoom right now for Barbara Shape? No. Okay, she claims that she can't.
Barbara is here.
Yeah. Okay, where's Barbara?
I'm right here.
Are you on Kenneth Mitz's phone? Oh, you're just on the audio? Okay, good. Do you have video capacity, Ms. Shape? How do you say your last name?
I have no, Scott, like school. I have no idea how to do that.
That's fine. That's fine. No problem. You're connected now by audio.
Right.
And there's an attorney for the plaintiff, Synchrony Bank, that's part of this Zoom right now. We just were getting started to talk about your case, and we were trying to see if anybody had your phone number so we could call you, because we didn't have you connected at that time. It was set for 8:45, and we've just been spending the last 5 minutes trying to figure out how to get a hold of you. So that's good that you connected.
Okay.
And again, you say it like Scott?
Scott, with a P on the end. Scott. Like
Okay.
Paul.
Okay. So this is the case where Synchrony Bank is pursuing you for an old debt that I think you talked about came to be because of the dental work that you had. And you were saying that you really, in your response back in January, 10 months ago, you were talking about not being able to afford it. You were talking about your two homes that you have, one in Cedar Springs and one in Sault Ste. Marie. You talked about your husband passing away, and I'm sorry for that, of course. And you talked about your daughter and her husband and how much help they were giving you at different times when he lost his benefits through the VA or the vet's benefits, and it created some difficulties for them wherein they weren't able to help you as much. Is that a fair way to say it?
Yes.
Now, what I'm trying to understand is, even though you're on Social Security, and even though you're dealing with all the issues that you've got, you really don't dispute that you owe this money. You just can't afford to pay it, and somehow you want them to write it off.
Well, I don't see any alternative. I mean, I don't have much income. I have to pay a house payment. I have to get heat and food and that kind of stuff. My medication, the copays on my medications, I'm diabetic, are, several $100s a month.
Right.
By the time I pay those things, there's absolutely nothing left. I am out of money every month before I get to the end of the month.
I'm not doubting any of that, Ms. Scott. I'm not doubting any of what you're going through, and I don't mean to be disrespectful in any way, but really, for a lot of people, we just call that life.
Well,
don't we?
I understand.
I mean, it's your life.
I've never.
It's what you're dealing with.
Been in this position. Yeah.
Right.
Well,
but really, the bottom line is, the bottom line is you don't believe there's any expendable income to pay it, but you don't dispute that you owe it. I mean, it's not like this is your twin sister. This debt was really
No,
your debt.
Yep, I agree.
Right.
But there's still nothing I can do about anything.
Well, if they try to collect it, like any creditor debtor situation, a Visa, MasterCard, J.C. Penney, any kind of a creditor debtor situation, if the money's outstanding and it becomes a judgment, we don't have a trial on a case like this simply on the basis that you don't have disposable income. They have the right to pursue whatever means of collections might be possible, like executing against property. I'm making this up, but just say you have a fishing boat on a trailer in your backyard, or you have a snowmobile, or you have a car. They have the opportunity. Go ahead.
I was going to say, they're welcome to come get my car. It's a 2004 Sonata that doesn't run, and it's all rusting away.
Right. I'm not doubting that.
I understand, and I agree. And I tried to call them, but they didn't even return my call.
Okay, well, let me do this. Let me put you in a conference room with the attorney that represents the bank right now. I can put you in a separate chat room. His name is Mr. Canine. It's spelled like canine, but you say it canine. And Ms. Shopt, what I'd like to do is just have you and Mr. Canine talk a little bit. See where you're at. Because I think this could be some resolution of it if possible, but I'll just first have you guys talk. Mr. Canine, are you okay with that?
I don't mind speaking, Judge. We've spoken a number of times, but I'm happy to speak again, sure.
Okay, do that, and then I'll bring you right back in. You'll be coming back to this Zoom room, Ms. Chopped.
Okay.
Okay. Just hang on.
I don't know how to do that, but I'm assuming that
I think we do it. I think we do it for you.
Okay.
If anything happens and you disconnect, just reconnect again.
Okay.
Okay, thank you.
Thank you.
Michael Nelson is here now.
Okay, thank you, Mr. Nelson. We were waiting for you and wasn't sure what was going on. Attorney Francis is here for this Automotive Credit Corporation. Ms. Gray, who was formerly Ms. Tallis, was part of this Zoom as well. And they were connected earlier, but now I don't see them on this. And okay, so now she's connected. So Ms. Gray, I want to make sure you can hear all of this. This is a file, Automotive Credit Corporation versus Christy Tallis and Scott Tallis. Ms. Christy Tallis is now Christy Gray. Scott Tallis is not part of this action today, or isn't appeared, or hasn't had anyone appear for him. Attorney Mike Nelson is here filing an appearance on behalf of Christy Gray, formerly Tallis. This is on file C09-2507GC. It's Ms. Gray's objection to the garnishment on the Lake Michigan Credit Union. And Ms. Gray was alleging that the monies that were in the bank account, a joint bank account she has with her current husband, were strictly unemployment benefits and her husband's inheritance from his grandmother. All right, so why don't you go ahead and state what your position is, Mr. Nelson, and then I'll let Ms. Francis speak on her behalf, on behalf of Automotive Credit, I should say.
We have filed a brief, and our position is that the funds in the bank account are exempt because they're unemployment compensation, and by statute, unemployment benefits are exempt from garnishment. Both of the people, Mr. and Mrs. Gray, both were receiving, their only income for the past several months has been unemployment compensation. There was this small inheritance, but Mr. Gray is not a defendant, so his funds are not subject to garnishment. So we believe that all the funds in the bank account were not subject to garnishment.
All right, let me have Ms. Francis respond to what she wants to say and then take it from there.
Judge, opposing counsel is claiming that unemployment funds are exempt, but they're not. The source of the unemployment is exempt, so we couldn't send them a garnishment to garnish those funds as we could for payroll. However, once they reach a bank account, they are no longer exempt. And even if Your Honor ruled that they are exempt, the case law that opposing counsel has attached, it's not binding. And either way, those funds have now been commingled. They were deposited into an account that already had over $5,000 in the account. So that made them commingled. And then they were again transferred to a savings account. We garnished the savings account, not the checking account. And the savings account had funds that were already in there as well. So now they've been commingled again. So these funds are not exempt either way that they are looked at. And so we are entitled to have this garnishment, and the garnishment has almost paid this account in full, Your Honor, now. This is a 2006 account judgment, so we are entitled to these funds. And so we're just asking for their objections to be denied.
What is the total amount that's being held right now? Is there a garnishment amount that's being held?
We've already received the funds, Your Honor. It's $10,407.68.
Okay.
So we've already applied it to the account, and her balance now is only $275.33.
And how long ago was that was garnished?
It was garnished in August
Of 2019 or 2020?
2020.
Okay. Okay, Ms. Gray, you don't have to say anything, but I wanted to understand, when was your divorce from Scott?
Go ahead.
The date that it was finalized, that I got the paperwork.
The year.
Oh, 2013, November of 2013.
And did this case started before that?
Yes.
Did this case have anything to do with the divorce? Like, did the divorce take into consideration anything on this case?
Yes, it did. It was stated in my divorce papers that automotive credit was not my responsibility, along with several other.
So you have the right to go after Scott for the $10,000 they took out of your account for this, if that's going to work.
Why? He's unemployed as well. He doesn't have anything.
But the judgment in the divorce said, Scott, you're saying to me, the judgment of your divorce said Scott was supposed to pay the Automotive Credit Corp.
That is correct.
Bill. Yeah.
Correct.
But see, at the time that you guys are getting divorced, Automotive Credit Corporation doesn't really care what your divorce says, because they have you both on this. So they're going to keep going after both of you until it's paid, just like they did.
Yep.
Okay, let
They
me
haven't gone
inquire.
after.
Go ahead.
I was going to say they haven't gone after him. They just have gone after me.
Uh-huh. Well, I don't know how he buys his bread and butter, but people have ways of getting monies together when they need it. My inquiry to you.
Out of prison.
Oh, well, if he was in prison, that would be different. I didn't know he was in prison. So,
Yes.
Mr. Nelson, how do you, I get how you're trying to use the unemployment insurance benefit as being non-garnishable, exempt, but how do you deal with her current husband's inheritance monies from the grandmother that go into a joint account? I don't get how you're saying that's exempt.
The husband is not a defendant.
Yeah, I
His,
get that.
his money is not subject to the garnishment for this case. And we
Uh-huh.
cited case law to that also. There was
Uh-huh.
in a joint account, there is a presumption that it's 50-50, but that can be rebutted. And in this case, it's clear whose money is which. So his money is not, no matter where it comes from, is not subject to garnishment in this case.
So when you're talking about him putting money into an account that's a joint account, if he died, she gets it.
That's
It's
true.
just as much her money as his. It's
That's
just
true.
as much her money as his. Same vice versa. If she puts her unemployment benefits in that account and she drops dead, he gets it. Fair enough?
That's true. I've
My
cited case.
inquiry to you, Mr. Nelson, my inquiry to you is, has your client taken the position from day one on this case, 2009, that she didn't owe it?
Well,
I don't feel that I owe it.
she may take that position, but we understand that this is a final judgment. So we're not here attacking the judgment.
Okay, but my inquiry is why, Ms. Gray, formerly Tallis, why for, the better part of 11 years? Your entire attitude has been you don't owe this.
No,
Not
that
my
is,
Your Honor,
problem.
no,
again.
that is not correct.
I don't get it then. I don't get it.
When I came before you before, we discussed that, but as much as I was married to him, you said a debt is a debt is a debt. But why is it only my debt? Why is what I'm saying? I've been paying it. I'm the one who has paid $17,000 prior to the $10,407 they took out of my account with my husband.
Right.
So
Okay.
again, when you're talking well over $27,000 from me, who at that point was a struggling single mom working 2 jobs, trying to provide for my 2 children, I was still paying on that.
Right.
I feel that I've paid more than my portion of that. And I've tried to make, I've been out of work. This isn't the first time I've been out of work. I lost my other job. I was paying, I tried making, like a settlement with them, and they were relentless. They would not make a settlement with me. So when I lost my job and I had no income and I wasn't married, I stopped paying on it. That was the only time that I did. I've literally been paying on this since the beginning. And I don't feel like I'm not saying it's not my responsibility. Obviously, my fault. I trusted someone whom I was married to. I signed on the line as well as him. But again.
But is it fair to say that during that entire time that you were making payments and during the time that you were not able to make payments, that entire time from when this lawsuit was filed to now, 11 years, just say 11 years, you've never once pursued your ex-husband for any of it?
As I don't really talk to him, and
yeah, I get it. That's why people get divorced.
Right,
but if
exactly.
a judgment in circuit court says he owes X and you owe Y, you'd want to get that squared away.
Right.
But you've never pursued it with him.
I don't know
Fair
where
enough?
I don't know where he lives, unfortunately.
Yeah, I get
don't.
it. Okay.
And
here's
and
what I want to do.
Your Honor, the fact is, it's very hard to collect from some people. This case is 16 years old or 14 years old. Obviously, we haven't been able to collect from the husband, nor, and I have not represented Ms. Gray until now, nor has the plaintiff. I'm sure they'd like to collect the money from him if they could. But nobody's been able to get money out of him.
Yeah, they would have gotten the money from anybody, which is why we're in this position now, because they did, after many, many efforts of trying to garnish, they did get the money, and now we're in this predicament. Here's what I'm going to do on the defendant's objection to garnishment. I'm not making a decision right now in order to have the plaintiff return the money to the defendant. I'm not doing that. I'm also not wiping out the defendant, saying I won't hear more about it. I want to see the bank records. I want to get into studying more in detail the issue of the unemployment benefits commingled with other funds, going from one bank account to another bank account, from checking to savings. And I want to find out whether the plaintiff is accurate in how they describe these monies are garnishable, or if the defendant is accurate in arguing these monies are not garnishable. I'm not prepared to make my decision today, although I did get the brief from the defendant on the question of whether the garnishment money is attachable or not. I want to study it more, because what's being presented by you, Ms. Francis, is the complete opposite of what's being presented by Mr. Nelson. And my only focus that I really feel confident about is the joint account with Mark's grandma's inheritance check that got deposited, because once that's deposited, you know, that's everybody's money that's on that account, even if you had your kids named on the account. My point right now is I'm going to set it up. Well, really what I'd like to do this, and I know you sent in your brief, Mr. Nelson, and maybe that's all you needed. I want to study that and have a better chance to analyze those cases that were cited. I also, Ms. Francis, want you to respond in writing in a brief form so that I can see it. I'm not setting it up for an evidentiary hearing right now, but I'm keeping everything the way it is right now. No monies are going to transfer back or forth. I want to find out whether the plaintiff was within their right to garnish that money. Do they get to keep it? Do they not? Because really, it's still a debt, and it still needs to be paid regardless of if Mr. Tallis is around or in prison or not. And I want to look into that very carefully to see whether the defendant's argument is viable. All right, any questions that you have, Ms. Francis?
No, Your Honor.
In the next 2 weeks,
Your Honor,
if you could respond, and then Mr. Nelson, hold on. In the next 2 weeks, if you would respond, Ms. Francis, and then Mr. Nelson, you'd have 2 weeks after that to respond to what she's saying. Now, what's your question?
No, you mentioned defendant's brief. We haven't gotten anything from the plaintiff. I wonder if there was one.
I don't think so, other than the motion itself.
All right.
But instead of having you prepare another one before you see theirs, I think you should see theirs and then respond.
Thank you.
All right, Ms. Francis, anything else?
No, Your Honor.
Okay, we're adjourned. Thank you for your courtesies.
Thank you.
Thank
All
you.
right, thank you. Thank you for zooming in, Mr. Nelson. Yep, and Ms. Francis. Okay,
Thank you.
Mr. Canine, you're
Yes,
still
sir.
with us, correct?
Yes,
Ms.
I am.
Shopt, can you hear me?
Yes, I can.
Okay, good. So you got back into this room together. I wanted to inquire whether your discussions just now, as short as they might have been, were at all productive or really not?
No, they were productive, Your Honor. We're going to enter into a consent judgment for the balance plus taxable costs, with the understanding that Ms. Shop, because her income is protected by federal law, probably won't ever be able to pay any of it. So, thank you.
All right, well, the consent judgment, Ms. Shop, does take it to the next step. Like I was giving examples about a fishing boat or a motorcycle, et cetera. You know, and
Yep.
when you're talking about your homes that you have, they can also put a lien on your property for when it's sold or transferred, et cetera. That's another aspect that is a possibility for them to collect. So while I recognize you believe it'll never be paid off, and really perhaps in your lifetime you're correct, I don't know that, but don't immediately think that it's all over. Are you with me?
Yes, I understand.
Okay,
You know,
that's good.
truthfully, if somebody gives me a lotto ticket and I win the lotto,
Right.
I'll be
I
happy
got
to
it.
pay.
Yep. I've had people use that lotto example before, and I get what you mean. All right, listen, I really appreciate you connecting to the court via your audio Zoom, Ms. Shop and Mr. Canine. We're adjourned on your matter. Mr. Canine, I'll ask you to prepare the paperwork.
Will do, Your Honor. May I submit it under the 7-day rule?
Yes.
Okay, very good. Thank you, Your Honor.
All right. All right. Thank you, Ms. Shop. We're done now.
Okay, Mr. Canine,
I think,
You're going to send me paperwork, is that correct?
Yes, I'm going to send it to the court and to you.
you'll get the
Okay.
same copy that we get.
Okay, and that's going to be when? How long?
With mail,
Within the next few days.
yes.
Okay, how long do I have to get it back?
You don't
Or
have to
can
get
I-
anything back to us. You don't have to get anything back to us. If you don't object to it, I sign it and it's the order.
Okay. That's,
Okay.
That's fine.
That's why I wanted to use
All
7
right,
days.
thank you for your courtesy.
Thank you.
Thank you too.
Okay,
Bye-bye.
okay, thank you. On the Kenneth Mitz case, Kenneth, do you spell your last name M-I-T-Z? You got to unmute yourself. You're muted. You're muted, Mr. Mitz. You're muted. Oh, brother. I'm trying to call him on the phone. Tammy Molenauer, can you hear me?
Yes,
How do you spell your last name? Mollenhour and then Metzger? Yeah,
Correct.
you're muted. We can't hear you, Mr. Mitz. You got to put the button that says connect to audio. We can see you on the video, but we can't hear you. If you're pushing any of your buttons and at the bottom of your computer, like there should be something that says connect to audio. Okay, well, forget it. I just have you on the
Okay.
phone, so we'll put you.
Okay.
Yeah, now you're connected.
can
Yeah.
Go ahead and talk. All right.
Can I
Mr.
say
Mitz, do
something?
you say it M-I-T-Z? Do you spell your last name M-I-T-Z?
Yes.
Okay, fine. Ms. Tammy Mollenhauer Metzger, can you hear me?
yes, and it is not Metzger, it's just Tammy Mullenauer.
Sorry.
That's okay.
Was it ever Metzger?
No.
Okay,
Well,
my
yes,
bad.
it was, and then I got married in November,
Okay,
but I didn't keep the
All right.
Metzger name with
all
that.
right. Are we good, Amanda? Okay, this is a small claims case, D20 C01119SC. It started out as a small claims case with the magistrate. You got a judgment, Mr. Mitz, against Ms. Mollenauer for $4,080. Now, how this started out, I'm not clear because I wasn't part of that original case. But there was an unpaid credit card amount, and you got to use the credit card, Ms. Mollenauer, but it
Yes.
was in Mr. Mitz's name.
Right,
Were you guys a couple?
yes,
So it's like a divorce with no marriage. You never got married, but you were a couple for a period of time. Then you separated or divorced, if you will. And he pursued your debt under this credit card that you used.
yep,
Okay. And when you filed the paperwork today, it was wanting to set up an installment payment, and you were hoping that you could pay $50 every 2 weeks. If you were working in school, do you teach or what do you do?
I'm a paraprofessional,
Yep.
so I'm an
And are you back,
assistant
kind
teacher.
of, are you back to school or is it virtual or what is it?
We're back to school now, but it could come to virtual, and that means I would only work 1 to 2 days a week.
Right.
So really, what I proposed was actually the best thing that I could come up with,
Right.
because I only work 9 months out of the year. I don't work in the summer, and I work part-time 28 hours a week.
Do you ever look for more work? Like in the summer when you're off, do you ever look for a full-time job,
Oh, yes.
but you don't work?
I do babysit my grandkids and things because my daughters are going to college and things like that. So
I see.
I don't get paid for that, of course.
All right. Mr. Mitz, you objected to this because you thought 100 a month or 50 every 2 weeks is going to just take too long to pay off.
That won't even pay the interest on the
Uh-huh.
loan.
When you had this set up originally, how did you do the credit card situation? You just let her use a credit card that was in your name.
Yes, well, she was having trouble the second week of her paycheck running short. So I said, take the credit card here.
Right.
And
But you're not really Fifth Third Bank, are you? Like Ken Mitz, do you run a bank yourself?
no,
I'm not trying to be too funny, but you get my point.
yes,
So you're in a relationship with somebody, and when they're having financial difficulties, you step up like a lot of family members do, and you help out. Then the relationship falls apart, and months or years later, we're in this dispute that we're in now, where she ran up a debt on your credit card and hasn't paid it, so you had to sue her in small claims court. It's like what I said, a divorce with no marriage. I don't know if you guys lived together or how long you were together as a couple, but you had to probably separate other stuff too, didn't you? Like who gets the microwave or who gets the toaster?
no,
Nope.
Nothing like that? Did you
No.
ever live together?
Yes.
Well, you had to separate when you moved out. You had to take whatever was yours.
Right. I took
you
my
ever-
things,
Yeah,
but
did
I
you
didn't
ever
take anything that
accumulate-
we bought together.
So nothing that you bought together, you just, how long was the relationship?
10 years.
Oh, that's a long time. Well, here's the point. And your name was never on that card. Fair enough, Ms. Mullenauer?
Right.
Yeah. It's not like you dispute you owe the money, and it was less money than Mr. Mitz thought he was going to get for whatever reason. He sued for the maximum in small claims and got $4,000. We all want to see this debt paid before any of us die. And I'm probably, I'm older than you are, Ms. Mullenauer, but maybe I'm more closer to Mr. Mitz, I don't know. But we're all in the age, you can't say middle age unless we're going to live till 120. So, you look at like how long is it going to take for you to pay this off and what your thoughts were in terms of using the credit card. Way back, we're going years back. I don't know how many years back, but we're going a long time back. To set up a payment plan, we need something to work. Because the minute you ask for this installment payment, if I say no to the installment payment, Mr. Mitz, you've got to try to garnish from her wages. You have to garnish from whatever school she's working at to try to get 25% of her take-home pay if she doesn't owe anybody else money. If you're the only creditor that's garnishing her wages, you stand a chance to get paid every time she gets a paycheck. What that does to your paycheck, Ms. Mullenauer, is cuts it right from your employer, 25%. So you look at what your check is every 2 weeks, even if you're only working 28 hours a week, part-time, you look at what your check is and you divide it by 4, your take-home check. So if you divide it by 4, Mr. Mitz gets 1/4 of it. I'm making this up to use numbers that I can add properly. I'm making this up, this part. But just say your check is $400. He gets 100, you get 3. I'm just using the numbers so I can do it easy. If your check is 800, you get 6, he gets 2. It's 1/4 of your pay. What that does when you get 1/4 less, it means all your other bills start falling apart. Can you pay rent? Can you pay groceries? Can you pay utilities? Can you even keep your job because you can't pay for your car or gas or maintenance? So now people lose their job. Now they have no income, which directly impacts you, Mr. Mitz, because if she has no income coming in, you can't garnish anything and get nothing. So what we try to do is we try to work for these installment payments where the installment payment will be manageable, but not crippling. If the amount of what I order you to pay, Ms. Mullenhour, is more than you can pay, you'll fall behind right away. And then it's a problem.
Yes.
And then we go right back to garnishment, which leads to these other problems I just described. You come up with 50 every 2 weeks when you go through what you pay for your other debts and what you pay for your Jeep Compass and what you pay for your kids or whatever, and it seems manageable. To Mr. Mitz, it feels like he just said, it doesn't even cover the interest that's still on a credit card that he has. Now, Mr. Mitz, what stops you to clear your own name for you to pay off your credit card?
What
I mean,
stops
aren't
it?
you, do you have the financial wherewithal to pay it off and still have this judgment with her?
No.
Oh.
The real,
So you're living off of your Social Security.
right.
Yeah. All I would do is ask you, Ms. Mullenhour, what is your paycheck that you get every 2 weeks? Ballpark, what is it? How much is it? I mean, have you looked at it lately?
It's
Have you
about-
studied it?
It's about
Somewhere
670.
between $600 and $800?
It's never 8, never 8.
Okay,
So I would say 6 to be clear. It's
6
usually
to
in the,
700?
yeah, and not even 700 half the time.
And you get that twice a month?
Yep.
When you talked about this babysitting in the summertime, do you get paid for that or is that gratuitously?
No, I babysit for my grandkids. Yeah. So that's,
Yeah, but when you're babysitting for the grandkids, your kids don't pay you, do they?
no. No.
I'm asking, why don't you have an income in the summer? I mean, isn't it kind of hard to make ends meet if you're not working all the time?
Well, it is.
I mean, I'd like to take the summer off too, but we don't get to. I mean, I
Right.
guess you could if you had a job that allowed you to, but can you afford it? That's the question.
Right.
And if you say
It's not like
100,
I've tried, it's not like I haven't tried to get a job in the summer. And I did have jobs in the summer prior to this. But I just, not
well,
every
it just
summer.
feels like you never get caught up. And that must be how it feels for Mr. Mitz. If the money doesn't even go to the ching ching in interest they're charging you on the credit card that they're charging him. But
Right.
what I'm saying is, I want to try to see if you can pay.
Can I
this
cut in
amount.
just for 1
Yeah,
minute?
go ahead.
Uh,
Yep.
Kenneth has owned a business for years, Cedar Cycle. And and I don't know if he still owns it or not, but him and his daughter, they were in it together. And when I was with Kenneth, he still owned that business, Cedar Cycle. And I think right now his daughter's trying to run it because he wants to retire. And he's actually tried to retire a couple times, but he's had some help that haven't worked out, and he's had
Okay,
to
get
work.
to your point. Get to your point. Is your
He's
point
not living,
he's
he's not
financially
living off from
stable?
Social Security.
Right, okay. So say he's a millionaire. Say he's a
He-
millionaire. I wish he was. I wish you were. But here's my point. That's got nothing to do with anything. He could have millions of dollars and you owe him this 4,080.
Okay,
It doesn't, we don't look at, well, how much money does he have? Oh, he's doing great. You're not. Oh, you're a single mom. He's not. We don't look at it like that, Ms. Mullenhour. Unless back at the time that you had this 10-year relationship that I have been calling a marriage with no, a divorce with no marriage. That's what I'm calling it. Because for 10 years, you're a couple. You had to do a lot of things together, and you chose to, both of you. Well, when you separated, you said, I didn't take anything we accumulated together. Okay, that's your choice. If you would have gotten an attorney, people don't have to be married to be separated. So there was action that you took to separate, And you know, he
Well,
had to
he
file
asked me
this
to
lawsuit.
leave.
Okay, it
Yeah.
happens.
Yep.
It always starts some way. Here's what I'm gonna say right now. Mr. Metz, we're gonna try the $50 every 2 weeks. It's gonna start October 15th. The 15th of October and the 30th. So every month, the 15th and the 30th of every month,
Okay.
a $50 payment without delay and without missed appointments or missed payments. If you don't pay or you pay less than the 50, all bets are off and you can garnish away, Mr. Metz. Right now, we're going to try this. $50, it's called bi-weekly, every 2 weeks. The 15th, I'm picking the 15th and the 30th because they're good numbers in a month that you can remember.
Right.
So the 15th and the 30th, and pretty much every month has that except February, I think, but whatever.
Right.
15th and the 30th, and just stick to it like glue.
Yes.
Now,
I
if
will
you
do
mess
that.
up, he should be able to garnish right from your school.
Right. I will not mess up.
Well, we'll find out, but it's still going to take next to forever to pay that debt off. If after a period of time anything changes, we can all come back and talk about it in court again, or you guys can work out something differently. Okay?
Okay.
You know, originally, she was
Yes?
gonna pay me, originally, she was gonna pay me $500 a month, which we agreed on.
I remember when Judge Bowler was involved in it, and he's a judge that substitutes for us, Judge Bowler. On the file, he said something about if there was an agreement to pay $300 a month. But I'm not doubting you've had other agreements. None of them worked. We're gonna try this, and if this doesn't work, we're going back to let you garnish the wages, Mr. Metz. We'll just try it. We can look at it. You can contact the court, Mr. Metz, if it doesn't seem to be working for you.
All right.
Okay, that's it. We'll give it a try. Do the best you can. Thank you for your courtesy,
Do-
both of you, for zooming
Hang on.
in.
Do I pay
Yes?
the court or do I pay Kenneth?
Kenneth,
Okay.
and it should be by check or money order so you can always verify what was paid.
It'll be by check.
That's fine. Thank you. Okay, we're
Do I-
adjourned.
So I have to have it in
Go
his
ahead.
hands by the 15th or write
I
the
would.
check on?
Mail it a couple of days early. He should have it by the 15th and the 30th of every month.
Okay, sounds good.
Today's the 6th, so I gave you enough days to do it.
Yes, thank you.
All right, thanks.
Yep.
Thank you. All right,
Thank
thank
you.
you, Mr. Metz.
Thank you. You take
Ms.
care.
Dawson, what case did you have?
I have the city of Cedar Springs versus Dan Rogers,
Uh-huh.
but I don't see my client here yet.
Okay, hold on a second.
Oh, she's still there.
You can disconnect, you guys. Ms. Mullenhour and Mr.
Okay.
Mitch, you can just disconnect.
Yep,
Leave
will
the
do.
meeting or whatever it's called. Is anybody for Dan Rogers part of this Zoom right now? Dan Rogers? Okay.
Your Honor, if I may, I have another hearing in front of Judge O'Hara at this
Why
same
don't you
time.
go over there? Why don't you go over there? We got your message. I'll just wait and come back when you're done with him.
Okay, I'll do that. Thank you, Your Honor.
Uh-huh. Do you know what happened on that Crawford case?
Judge, I am on the phone. This is Jim Burr.
Mr. Burr? Sure. All right. And I see Mr.
I was originally
Hennefeld.
told to contact Judge O'Hara, and then I got a call yesterday that I should be calling you instead.
Right. Okay, you're in the right place. Mr. Hennefeld, can you hear me?
Yes, I can.
Okay. Mr. Burr, do you have video capacity on your equipment so you can join
I do,
video?
but right now we're having some problems with the
All right,
with the
that's
camera.
fine. That's fine.
And I
And
wrote
do
a
you
letter
have-
to I wrote a letter to Judge O'Hara indicating this, and if I could make it appear by phone, and I didn't hear anything back from him.
Right. Yeah, the case was always assigned to me, so I'm not entirely clear how it got mixed up, but let's just deal with what we have right now. I'll go on the record on D20, C01-667GC. This case originally was Nancy Preby versus Applied Asphalt, Matthew and Jamie Riley. Now, Mr. Hennefeld, who do you represent?
I represent Matthew Riley.
Is Jamie a spouse?
Yes,
Are they still spouses?
yes.
All right.
So,
And is Applied Asphalt an LLC?
yes,
Okay. And Mr. Burr, you represent somebody by the name of Crawford Lake Nature Estates Association?
I do, Your Honor.
All right. While I reviewed the file yesterday, I did not have Mr. Hennefeld's brief that came in at 5 o'clock last night via email. And I don't know if you have a copy of it yet, Mr. Burr.
I
it's his-
do not.
But it's his brief in opposition to your motion for the default judgment. It's also a motion that he wanted to set aside the default. Now let's just talk for a second, gentlemen. And I don't know if your clients are on board or they can hear us, but you can fill them in clearly. This case started as a small claims case where this Nancy Preby, who evidently was some representative of this condo association, but unclear at the time, she filed it in her name only against Applied Asphalt and both Matthew and Jamie Riley. Before it could be heard by the magistrate in small claims, Matthew Riley removed it to the general civil docket. At that time, and I may not have the details exact, you guys can look into this, there was discussion about the wife, Jamie, wasn't really involved in any of this, and somehow she should be dismissed as a party. And I don't know if it was Nancy Preby or somebody else that agreed to that, but then it kind of looked like Jamie Riley's name was taken off it. On or about that same time period, while it was never filed, or it was never scheduled in front of the judge, there wasn't a response at some point, and so the plaintiff thought they could get a default judgment. So then Mr. Burr got involved, and I might not have all the chronology exact, and everything you wrote, Mr. Burr, was naming Crawford Lake Nature Estates Association as the plaintiff, and that this Nancy Preby was some kind of an office manager or agent of the condo association, if I'm saying it right, that it's a condo association.
That is correct, Your Honor.
The predicament that it causes me at this point is we can't just automatically change the names of the party. Nancy Preby, in her own name, filed this lawsuit, in my opinion, incorrectly, because she wasn't the party of standing for this Crawford Lake Nature Estates Association. And then you, Mr. Burr, albeit getting into the case later, never filed a motion to have Crawford Lake Nature Estates Association be the plaintiff, but now file a motion to enter a default judgment. And it's just been done improperly. The whole thing has been done improperly. Now, to be honest with you, Mr. Henneveld, I didn't read your whole brief because I've been in court since 8:30 and I left here last night at 5. I never saw your brief then. I got it this morning, but I probably had seven to 10 cases already this morning on Zoom. I get the gist of your motion, but I didn't read it verbatim.
I apologize, Your Honor. I was brought into this Friday afternoon
I get that.
over the weekend, and
I get that.
so I
Here's what
apologize.
needs to happen. I got a couple of choices, the way I see it. I just dismiss the entire case and make you guys start over. Or I allow Mr. Burr to amend the pleadings to name the correct parties, to put in what the complaint is so it's very, very clear, because now he's asking on the default judgment for treble damages. Your brief, Mr. Henneveld, explains a whole lot of defenses that you have regarding the original complaint for the $5,000 asphalt job, claiming weather is the biggest part of this whole problem of why it couldn't be done. And then your clients were told they cannot come back and do this. So your position is they were somehow prevented. That's the bits and pieces I got from the very brief review of your brief I did.
And there's one other.
But Mr.
if
Go
I
ahead.
could, there's one other important factor. That is that they have named Matthew Riley individually rather than the LLC.
Okay,
And their explanation was that the LLC was not in good standing, therefore the corporate veil basically was pierced, is what I assume that they're claiming. But if
Okay.
you look at the brief, the statute specifically states that even if an LLC is not in good standing, it still exists and can operate in the state.
okay. Well, obviously, that's another issue that needs to be addressed. But let me hear what your thoughts are first, Mr. Burr, about the options the court sees as dismissing this entire case without prejudice and allowing everybody to start over, or allowing the parties to amend the pleadings and let everybody have full knowledge in response to all charges, all complaint allegations. Go ahead.
I think the second alternative, Your Honor. We filed an amended complaint expressly dealing with exactly what you have just indicated. And we've sued Riley. Basically, his entity is defunct under Michigan law, and we have to, and so therefore we're suing him individually. This is
When did you
something I
file
think-
the amended complaint?
The amended complaint is dated March 18, 2020.
Uh-huh, okay.
And we've tried
All
to
right.
get through, but because of the scheduling problems and certainly the COVID situation, that we've not been able
No
to
doubt,
get this.
it's been difficult for everybody, no question. Mr. Hennefeld, do you have any response as it relates to option number 2, allowing the plaintiff to file their amended complaint that you'd get a copy of, and then allowing you to respond in answering the amended complaint or any complaint, counter complaint that you may have?
I think it would be much cleaner to start from scratch so that
Right.
everything is put behind us. So
Uh-huh.
I would prefer that, Your Honor.
Okay. Okay. All right, anything else that you want to say at all, Mr. Burr?
Well, Your Honor, this is another stall. We've tried to get something done. We've written to the defendant. Nothing has happened. He's totally ignored the association. He's totally ignored my letter to him. And now he's coming in and trying to get a little bit more extra time. And I think that the easiest way that if there's been a brief filed, which I haven't seen, if the court will grant this motion to change the name of the plaintiff to Crawford Lake Nature Estates Association, and it would not include his wife. It would simply be Matthew Riley, DBA Applied Asphalt and Seal Coating, LLC.
Okay. Other than your argument you just made, Mr. Hennefeld, about being cleaner, anything else you want to say?
No, Your Honor.
I'm going to allow the amendment to the complaint to name the new party Crawford Lake Nature Estates. My understanding then, Mr. Burr, is that Ms. Preby's name is taken off the case entirely.
Yes, ma'am.
And part of my reason for doing so is that they're filing fees that have been made. There may have been some fees associated with transferring to civil, I want to keep everything the way it is and not have there be more costs or have to transfer costs. I want the plaintiff to be given 2 weeks for any amendments to the complaint, and the defendant would have 2 weeks thereafter to respond and answer, file an answer, or any kind of counter complaint. Does everybody understand where I'm coming from, Mr. Burr?
I do, Your Honor. May I submit your order under the 7-day rule?
Yes. Mr. Hennefeld, can you answer, or do you have any questions or confusion at all as to what I've tried to express?
Not as what you expressed, but we did not address Mrs. Riley. I believe
She's
that-
off. She's dismissed from the case. That should be in the order.
All right, very good. That's
You
all I
don't
have.
dispute it, do you, Mr. Burr?
No, Your Honor. In fact, if you see
Right.
the amended complaint we filed, we've taken her name off.
Okay, that's fine, and that would stand in good stead with your client since he's the husband of her. Anything else, Mr. Hennefeld?
No, Your Honor.
That should be in the order that you submit, Mr. Burr. Submit it under the 7-day and take a look at it, Mr. Hennefeld. If there's any problems, we can have a 3-way phone call.
Now, Your Honor, I do have one more issue. Is,
Yes.
my request for attorney's fees. Now,
Respectfully
What?
denied. Hold on, Mr. Burr. Act as if you were in the courtroom right now.
I'm sorry, Your Honor. It's just I was just
Yeah, well, your
startled.
response was off
I
unnecessary.
apologize to the court, Your Honor.
Mr. Hennefeld, I'm not going to address the issue other than to say it's respectfully denied at this time. While we get into this case, and because it's a continuation of what we had, I won't prevent you from presenting any other motion like that in the future if you feel that it's necessary. But right now, I'm not addressing that other than to say respectfully denied.
So am I preserving then the right to request it for this particular hearing in the future if I feel it appropriate?
Yeah, I think that's fair.
All right. Thank you, Your Honor.
All right. We're adjourned then, gentlemen. Thank you for zooming
Thank you,
in. I
Judge.
appreciate your courtesy. Thank you.
Thank you.
Bye.
Uh-huh. Yeah, until Ms. Dawson comes back. Has anybody for Dan Rogers appeared? Okay.